I'd like to call this work session to order on AO 2021-50, amending Title 8. Let's go ahead and start with the roll call, and I'll just note for the record that Ms. Allard, Mr. Constant, Mr. Dunbar, and Mr. Presverdia are excused. All right, go ahead.
Thank you. Mr. Rivera?
Present.
Mr. Weddleton?
Here.
Ms. Allard, Mr. Constant, and Mr. Dunbar are excused. Ms. Kennedy? Here. Ms. LaFrance? Here. Mr. Presverdia is also excused. Mr. Peterson?
Present.
Ms. Zalazal?
Ms. Zalazal will be a little late, but she'll be joining over the phone. Okay, so for folks on the phone, please text me if you want to get in the queue. Otherwise, if you're in person, just flag me down. I'll go ahead and turn it over to the administration for the presentation.
Thank you. This is actually Sarah's family. I believe Kate Local is there in person. So I have a PowerPoint here, which I believe she's helping me with. And it basically is a shortened PowerPoint version of the memorandum that we wrote to go with this ordinance. So kind of broke it down by each change. So if we could go to the second slide, slide 2. So the first change is to 8, 10,
Actually, if you can just pause a second, we're changing the slide right now.
Oh, okay. I will make sure to wait.
Chair, could that be email for us on the phone?
The deputy clerk advises me that it was sent out this morning.
Thank you.
Okay, go ahead, Ms. Stanley.
So the first change is to 81030B on slide 2 of the PowerPoint. And it changes a couple things. So it became complicated at that, so we ended up just deleting the current language and rewriting it. The first thing it does is it actually decriminalizes negligently permitting injury to a child. So the example would be you're watching your child at the playground and you look away for a moment and your child falls and hurts himself. The police really don't send those cases to us, and we would probably not prosecute them because they're really, I don't think the community or jurors would be interested in really putting people in jail for that. And so I think on a practical level, we're not prosecuting that anyway, and so it makes sense to raise the lowest level of intent for just causing simple injury. We're not talking about other things like torture, but just simple injury to a child to reckless or cause. So that's one of the first change. The second change is that the previous language, it used to say if you're guilty of physically harming a child, if you did it intentionally, knowingly, recklessly, or negligently. It listed all 4. That's kind of cumbersome language, and it really confused juries and made it harder to actually get the conviction. So we changed the language to just be reckless. So if you recklessly cause or commit physical injury to a child, then that would be the level of intent required to be prosecuted. Because if someone does something intentionally or knowingly, they're also reckless. So it kind of includes the intentional and knowing as well. But it causes less confusion for the jury. Any questions on those 2, or should I keep going?
Ms.
I will
Kennedy?
keep going.
Actually, Ms. Stanley, I do have a question from Ms. Kennedy.
Yeah.
Thank you, Ms. Stanley. I guess my question is just in terms of who we're talking about in terms of a defendant. You know, I obviously can see where this has, it pertains to a person that is a parent or a guardian. Potentially, can a defendant be a neighbor who maybe watched the little toddler next door walk out into the street but didn't go and grab the child and they get struck by a car or something? I mean, to what extent does the defendant, or is the defendant identified? Thanks.
code, that person has never been identified. I can say though that I've never seen, the only times that I've seen these cases come to us is when it's either the caregiver. So either parent or, child care provider or, grandma, grandpa, that kind of thing.
Okay, thank you. So
So
someone who has direct,
responsible for the care of the child on a practical level. Sorry, go ahead.
okay, thank you. So somebody who has direct authority or control, or supposedly should have that authority or control over the child.
Well, that's the reality of how they're referred to us. However, you're right, that language is not in our code. 100%.
Okay, thank you.
The next change on this slide talks about the level of intent for torture, cruel confinement, or cruel punishment. And for that, we have a little standard, which is negligence. So even negligently allow a child to be tortured, that's a crime. Because remember, we just said that for just simple injuries, like a bruise or a cut, it's a higher level, it's reckless. You don't want to prosecute people who, all parents have had their kids be injured, right? We don't want to prosecute negligently just harming, but torture should be a lower level than that, right? So that is still negligence with the lower standard, and that's what it was before. We're not actually changing that. We're leaving it at negligence, where we really did a simple injury to record. Any questions about that?
I don't see any questions.
Okay, so going to slide 3. Are they early? Ms. Vogel?
Yes, go ahead.
Okay. So sections C and E and F, which will be on the next slide, we are deleting all of these sections. C and E here basically a parent in a primitive defense that says they can argue error innocence if the action was reasonable parental discipline. And then it sets a bunch of factors that jurors are supposed to weigh to figure out if the action was reasonable parental discipline. We want to get rid of this language because defendants already have a necessity defense that's actually defined in state law, which any citizen can use as defense. So this is redundant. Also, the Court of Appeals has noted that not an unpublished decision, but a decision that they find this language problematic. And there's a couple reasons. One of them is that these fact choices confusing, some of them are objective and some of them are subjective, like a parent motive of the parent. And so it's confusing with the factors for jurors to weigh. And also there's a possibility that this really constitutionally puts the burden on the defendant to sort of argue that element of a crime, which is not permissible either. To be fair, the Court of Appeals didn't really explain why they thought it might be unconstitutional. They kind of said that in the side. But I think there is some burden shifting. Usually the burden is on the prosecutor. To prove on the elements of the crime, this might unduly burden the defendant to prove elements. That might be what they were, hinting at. It's kind of hard to tell because they didn't explain. But they did make clear that they don't like this list of factors. It is confusing to a jury. And I think it's kind of limiting. So basically, when we ask a jury to find someone guilty of child abuse, an effective defense, which they can use from the state, says it is a defense. If you see something that injures the child, it's for the welfare of the child. So it will ultimately be up to the jury, if the parent uses that defense, to use their common sense and all the factors they can think of, from their life, and from the jury instructions that the attorneys will hash out, to figure out a way to decide if something is really for the welfare of the child. So we can do that in other ways through jury instructions. We don't need this itemized list. It's not helpful and it's confusing. Any questions on that one?
I'm not seeing any questions.
Okay. It was 5-4. This is the meeting, actually, or one of it. If you complete, yeah, still relevant. The Court of Appeals also finds this one problematic, and some of my prosecutors feel very strongly personally about this section. It states that these behaviors, like scalding, branding, or burning your child, are prima facie unreasonable. That means that assumed it's unreasonable, but that can be overcome. Say it's really great parental discipline somehow. So we find that problematic because we don't think that really branding your child should ever be found to be reasonable. And the Court of Appeals said the same thing in the published opinion. So we don't really believe it should be a rebuttable presumption. The other problem is that whenever jurors see a list like this, they think, okay, these things are reasonable. That means that anything else a parent does must be reasonable. So if we're trying to prosecute someone, say, for putting their child in an ice bath for half an hour, the jury might say, oh, that's not all things that are reasonable, so maybe it's okay. So it causes confusion for jurors to have this list that only is a few items, and then the prima facie unreasonable is also going to be given to jurors. Any questions about that one?
I'm not seeing any.
Okay. So that's it for the child view changes. The next section that we want to make some changes to was harassment. And the first change we want to make is to section A of it, which changes a couple of things. First, we want to lower the level of intent from intentional to reckless. And we also want to change the language of the action from, so previously it was a crime to intend to harass or annoy. We want to make it to act with reckless disregard for harassing or annoying effect on a person. We're trying to address the scenario where, say, a man reaches up a woman's skirt. And under the current language, all he has to do is to say, well, intending to annoy her, I thought she'd like it. And that's what we call it under the current language, which makes it hard to prosecute. So we want to refocus it from what the defendant's intent was and get really about the defendant's disregard for object citizens. Any questions about that?
I don't see any.
Okay. Slide 6 is about, again, harassment, but it's A2. We're making a couple changes. One of them, this is the section that prohibits publishing basically pornographic pictures of another person. And we see this most often with domestic violence situations, where we have a domestic violence defendant who has a victim who say he's assaulted, and then he threatens her, saying he's going to publish a bunch of pictures or send them to her parents or to friends and family, and we can't prosecute it because he doesn't actually send them, because she ends up complying with him and doing whatever he wants, maybe retracting, recanting her statement about an assault, or not leaving the home, or whatever behavior he's trying to induce. He never actually does it because she complies, and then so there's no crime. So we would like to criminalize threatening to publish or distribute, because that's really the mechanism of control that contributes to the domestic violence cycle, and that's what we see all the time. So that's the first change there. The second change is there's this list of media that printed photographs, pictures, images, or films that show the genitals, etc. We want to add in images and videos, because videos are a new, very common thing. Anyone can take a video with their cell phone, so we think that should be included as kind of media is relevant. And also images. Sometimes there are images that aren't pictures. They can still be embarrassing and blackmail material. For example, photos can be doctored. I mean, you could have someone's face with someone else's body, and for all intents and purposes, you just publish a pornographic person of someone because their face is on that image thing. That's just an example. Any questions about those?
I don't see any.
Okay. Thank you, Mr. Rivera. I appreciate it. Number 5 is changing another section of harassment. So previously the language was that it was illegal to subject another person to offensive physical contact. And the offensive contact was with someone's genitals, buttocks, or breasts. We wanted to add the word unwanted so that it's illegal to subject another person to unwanted or offensive physical contact. Offensive is a pretty subjective standard. All the jurors might have different ideas of what offensive means, and that can sort of, derail the whole conversation in the jury deliberation to figure out what a common subjective standard for offensive is. And really, what matters here is, this is touching people sexually. What really matters here is whether it was unwanted by the victim. So we wanted to add that language. So jurors could either find someone guilty of this if they touch someone's genitals and it's offensive, or if it's unwanted. Either one. The second change that we made here is that previously, in our current code, it is illegal to touch genitals or breasts or buttocks through clothing, but it's completely legal to do it without clothing, to have direct contact. Probably the reason that developed that way is because some of the higher level sexual assaults usually can go to the state. Unfortunately, we often get cases from a state that may have originally been referred to as felony. However, they just don't have the proof to really prove the full sexual assault sometimes, and so they send those cases to us. And if it's direct touching, not too close, we have no way to prosecute it. So we would like to make it also illegal to touch someone's genitals directly, not through clothing. So that's kind of fixing a loophole problem that we had.
Thank
Any
you.
questions on that?
Mr. Weddleton?
Yeah, just backing up a moment on that first sentence of that section. So, unwanted, I think this is years ago at my business, I had an employee just like a hug. He was a hugging guy. Most people were fine. It didn't matter. But another employee absolutely refused to be hugged. And he gave her a hug, and she just freaked. And, she was going to work. That's fine. And we worked it out. But so what would happen the next time? Could she say that was harassment? He didn't know until she told him, and then he stopped. And so it was handled, maturely. What was he subjected to because he just didn't know?
So this is specifically a person's genitals, buttocks, or female breast. So I would think that if police were called because someone was hugged, and I incidentally gets pressed against a female breast, but it's not the same as grabbing someone's female breast or buttocks or genitals.
But that's not clear in 4.
Yeah, you have to read
It also has to be.
Oh, I can go to if you go to ambient monitor. Okay, so this case I got you. Okay, thank you.
Did I answer your question?
I answered it by reading it.
Thank you. All right, I don't see any other questions.
Okay. Slide 8. What slide 8 does is previously some of these were Class A misdemeanors and some were Class B. We would like to make the section about publishing pornography of another person without their consent or threatening to. We would like that that to make that a Class A misdemeanor, because we think that is just as damaging as unwanted sexual contact or subjecting another to bodily fluids, which are the two other sections that are currently Class A misdemeanors. And to put it in context, the other two that would remain Class C misdemeanors would be taunting or challenging language, or touching another in an offensive manner that isn't sexual. So we think that sort of the pornography section really should be a Class A misdemeanor in the same category as the other sexual offense. And we really, unfortunately, we really see it a lot in the dynamics of their domestic violence abusers and victims. Number 9.
Hold on, before you...
Oh, sorry, I forgot to ask. Yeah.
Actually, we're good. Go ahead.
Slide 9 is making one change to the criminal mischief crime. Criminal mischief has a number of sections, but two of them, sections A1 and A7, are damaging property. So A1 is damaging property $50 or more. A7 is damaging property in values less than 50. Sometimes we see these cases in non-domestic violence settings, someone just damaging from property. So we see these all the time in domestic violence. These are usually in our domestic violence crimes, where there's a domestic violence incident, the argument gets heated, someone is assaulted, property is damaged, property is thrown, valuable property of the other person is damaged on purpose to sort of control the situation and win the argument. And we want to change it from, we want to drop the intentional language. So, the simplest example is the DV abuser punches a hole in the wall next to the victim's head, for example. If we delete intentional, right now it says damaging property of another intent to do so. If we drop it and just says damaging property of another, then we have this default level of intent that in our code is at 8510, and that default language says it has to be knowing to conduct and reckless as to result. In other words, in the scenario with punching the wall, the person would have to know they threw the punch, and they would have to have a reckless disregard for the fact that it was damaged property. And the reason we want to change that is this is another one where someone could simply say, well, I didn't intend to put a hole in the wall. I intended to, scare my victim. My goal wasn't to break the wall, or I threw that vase at someone's head. My goal wasn't to break the vase. I intended to scare my victim. So this kind of gets rid of that excuse and just says, if you knowingly, damage the object and you knowingly did the action to damage the object and you had a reckless disregard for the fact that it damages the property, that's good enough. So, any questions on that?
I don't see any.
So that's all the changes. And these really come from, all these come from places of frustration, from experienced frustration from our TV attorneys who have been doing this a while, because they have actually run into these difficulties that we're trying to fix. So these are our best attempts, and it's a pretty good attempt at a practical fix that would really help our prosecutors really address some of the cycles, especially of domestic violence that we're seeing, and especially the control issues and the continuing cycle.
All right, thank you. So I have a few questions. Mr. Weddleton?
Well, thanks. Thanks for the presentation. I guess I read this a week or so ago, and I have some scratch notes on here that I'll have some questions. One is, so we've deleted this reasonable parental discipline phrase. So are there any changes here that would decrease reasonable parental discipline?
Do you mean make it harder to use reasonable parental discipline?
Yeah, we've got a couple of emails. I think we all have to say, you're taking away parents' rights to raise their kids the way we want them to, or are we just saying, well, no, we can't work on them?
What we're saying is, if you want to argue that what you did was in the best interest of the child, you can use the state necessity defense as your defense. It's simpler, and in some ways it's better for written and less confusing for a jury. We don't need to have it in our code.
Okay, and I guess that's at AS 11.A1430 or AC A1, is that right?
Yes. Mm-hmm.
I don't have that memorized, so I'm reading my notes here. So,
Well,
is there, you know, it says that when normal people read this, they gotta go look at it. Is that short enough that it could be included in here? So people could read it and have the full picture all in one package?
That would be, I mean, that would be a possibility. So you mean just copy the state language and include it?
I mean, I think we do that sometimes, or even, I mean, someone we're looking at, is it in the AM at all?
Or,
Put it in there.
it is in the AM. And I think if we were gonna, if we were gonna put a site to somewhere, I would rather, we have a sort of general principles section of our code, and it might make more sense to put it there, you know, to say, you know, something like all state necessity defenses, you know what I mean, are, you know, work in the city, even though we know that's true anyway. It's something, you know, acknowledging that all defendants in Anchorage cases have the necessity defenses listed in state code.
Okay, yeah, see, I got notes all over here again, so sorry, Mike. Okay, yeah, I think, you know, when I look at these things, I look, okay, a normal person's reading our code, can they make sense of this? And of course, you get into a lot of legal nuances, like, I guess another question is reckless disregard. And we talk about subjective, right? Or is that clear somewhere?
Right, so, right, yeah. I mean, most of the intent or something we argue about in law school, you know, where the lines are between those and that. I mean, those are the same levels of intent that are discussed in other kinds of law too, not just in the law. But yeah, for a lay juror to sometimes figure out what they mean, basically they rely on jury instructions, and so that's why a big part of trial is the two attorneys hashing out exactly the right phrasing of those jury instructions. So that's litigated. Like every time a jury gets instructions on these issues, it's litigated by both attorneys before the jurors ever see them. So that's actually part of the trial process, is to educate the jurors on the case.
Okay. Okay, I guess that's all. I guess, you say, can I go more?
Sure, go ahead.
Okay. So in a sense that these are all just, you run into practical problems, and this is just making it work better. That's definitely the thing you should do. But so is this, you know, we have a horrible domestic violence problem in Anchorage. You'll get more convictions or get more people in the forces in the anger management or something. What's the ultimate result with these changes? You know, kind of on the ground with people getting along.
Well, for the whole for the harassment and the criminal mischief crimes, especially that are more sort of you know, domestic violence often between intimate partners or family members. Yeah, we can basically if we get a conviction, we can have people either do a fine or jail time, but also usually the DD convictions, our standard offers are anger management or domestic violence intervention program, or sometimes drug treatment, or sometimes ASAP, which is alcohol treatment. If we get the conviction, we can have them do things as conditions of their probation. If we don't get the conviction, sometimes we can have people in our programs for a deferred sentencing agreement, which is kind of a softer agreement, which results in reductions, but it's a lot harder to get them into those programs. Sometimes we can, sometimes we can't.
That's true. All right. Thank you, Chair.
Thank you. Learning up for the record, we've been joined by Ms. Salatel. Ms. LaFrance?
Thank you, Mr. Chair, and thank you to the presenters for the information. I have a couple questions. One on section 8.20.010 under the criminal mischief and the intent. And I see in the AM there's a reference to 805.010B that you mentioned. And I was just curious, I understand why the intent language, why it's important to drop that. And so if there are instances where something is, someone planned to do it and that made it worse, is that something then that would be covered under state law or, potentially as a felony? Or I was just curious as to how that part could be addressed. So that's the first question. And then the second question concerning section 8.10.110 under harassment, and in particular to the publishing or distributing of images and videos. And I recall in a public safety meeting at one point we talked about the issue of minors and texting, and I was just wondering how the change in the violation level, do you see any impact on minors or students who engage in this behavior, or if that's just not something that's relevant in this section? Thanks so much.
Sure. So let me do your second question first. Anytime there's child pornography, it automatically goes to the state because it's a felony. So we wouldn't be prosecuting anything with kids under this section. So that would be a state crime. This is particularly, specifically for publishing pictures of adults. Did that answer your first question?
I think so, so that if it was an instance of students and they were under 18, then it would not apply here.
Well, I would have to look at the state code, obviously, to double check. I know, but child pornography is a felony. And usually if it's electronic, actually the sex permit is prosecuted federally. Now, I don't know the definition off the top of my head of where that top cap in each one is, if it's 18 or 16. I would have to do some legal research on that on my own. But this would only apply, if the child pornography law applies, which is state or federal, that would be prosecuted that way. It would come to our office at all. So I've never seen a case of a child that just comes to my office. Those are usually investigated by the FBI and federally charged.
Okay, thanks. That does answer that question.
Mm-hmm. And did you say that was an answer? Or?
Yes, I'm good. Thanks on that one.
Okay. Thanks. I'm on a questionable signal, so I'm glad I can hear you well. Let's see. The other one, criminal mischief. So a lot of our crimes, I think, a lot of us know about things like manslaughter and homicide, where higher levels of intent, higher levels of consequence and sentencing. That's not the case with most, with misdemeanors, really, with lower level crimes. For example, for a simple assault, which, and I don't mean, it doesn't mean anything, just simple in terms of non-permanent, serious, disfiguring injury. But someone beats up their spouse with their fist and causes death and causes injury, not serious injury at all. That kind of assault, the standard is reckless under our code. There's no higher crime if someone did it intentionally. Really none of our crimes have different levels based on the level of intent. Our code basically is, assault is reckless, which is why I think it would be, the default would be appropriate in the situation. Because you just, you to know you did it, but having it be reckless as far as not caring about disregarding the consequences of the actions and the damage to the property actually matches the level for assault. And often these two go hand in hand in domestic violence situations, as I said. There's a physical assault, things are thrown, property is damaged, and to have it all be that standard of sort of reckless intent as to the result of damaging the property doesn't make sense. So I think, I think the higher level felony type crimes, like for example, the homicide and slaughter type crimes, where that intent really aggravates it, We don't have different crimes for the different levels. Though, however, I mean, if you can really show someone intended it or premeditated, those are all the arguments for sentencing. So once someone's found guilty, we have sentencing hearings, and all of those things can be argued to the judge to get a more serious sentence.
Thanks, that's really helpful. Thank you, Mr. Chair.
Thank you. Ms. Kennedy?
Thank you, Mr. Chair. Ms. Stanley, I want to go back to the section on abuse of a child or vulnerable adult and talk about the term tortured. I think for most of us, we have a pretty horrific sense of what that could actually entail, but I didn't see any place where the word is actually defined. And maybe it's not particularly in this section, but anyway, and I guess my question is in regard to, you may have answered it a little bit with Mr. Welleton's question in regard to how the court would handle it with giving jury instructions, but I'm just kind of wondering to what extent that word is defined so that it's not too subjective. I can certainly tell you from a parental standpoint that denying my child access to video gaming for a week was considered torture. So, but anyway, I don't mean to demean the awful incidents that happened, but anyway. So, can you help me a little bit with how we differentiate something that really is torturous versus something that is just punitive in nature, but not necessarily torture? Thanks.
Yeah, we don't have the definition of torture, you're completely right. It would be hashed out in jury instructions, and probably both attorneys, the prosecutor. So when we get a jury instruction, it's actually the prosecutor that shows up with the proposed jury instructions, which is, we have framed the instructions to start out. The defense can object to various instructions, and then it works out with the judge. So our attorney would likely, come up with a definition borrowed from somewhere else in the law, or it's been used in other places, and then it would be decided by the judge and the defense attorney. Honestly, I am not going to specify the line prosecutor. The only case I can think of that sort of came close to that line of the torture does kind of imply unusual harm, right? Like not spanking your child, right? But something more unusual. I haven't seen a case that I would call personally torture yet. We have seen things like the cold showers and making your child eat hot dogs. That kind of thing. And then we have seen, quite a lot of just really severe injury to children. Or withholding of food, that kind of thing. So I haven't actually seen the definition of torture litigated, I think, because I haven't seen a case where that strong word really actually has seemed appropriate where another word didn't. I have seen burning cases where children have scars and burn, but not sort of undefined vague torture like that. But it would be solved in jury instructions, and we would borrow from the law somewhere from another state definition or another jurisdiction.
Thank you, Ms. Stanley. Yeah, I hate to leave it up to one of those phrases like, we'll know it when we see it kind of a thing, even though I think that's true. There are some things that go beyond the question, and you know it. But anyway, so I appreciate the conversation, though, that obviously would occur in court. In regards to how to really identify that, and I appreciate the fact that there really isn't a true definition. So, but I do have one more question. Can you speak a little bit to the number of cases that we currently have right now that fall under this title? And would any of them be differently impacted if this were to pass? Thanks.
Oh, that's a good question. So that would be, so basically we have 4 DD attorneys who all have several hundred open cases right now. Those are all prosecuted under Title 8. Well, sorry, under abuse of the child, sorry, let me back. I apologize, that was incorrect. So we're just talking about abuse of the child, harassment, and criminal mischief. I don't have a number. I can say there's a lot fewer child abuse cases than there are, say, domestic violence assault. They're much rarer, thankfully. I mean, I'm glad. I hope that doesn't mean that we're just not hearing about it. You know what I mean? It's not coming to the authority's attention. What's much more common are the DV assaults. I would say, I'm just really honestly guessing, but I would say about 3/4 of our domestic violence cases, well, more than that, maybe 4/5 of our cases are assault. And many of them, a very high percentage of those assault cases, I'd say, well, actually maybe half, again, I'm kind of guessing, also have a second count, which is criminal mischief, which is that damaging of property. So that's like a very common partner with domestic violence assault. Harassment, the harassment sections we're talking about are rarer than domestic violence assault, terrorist, criminal mischief. So I would have to pull the numbers on abuse of the child and harassment. There's a lot fewer of those than there are of assault/criminal mischief incidents. So basically domestic violence disturbances. I could probably, today's Friday, but by next week I could probably get you those numbers. If you wanted the number of open cases of abuse of the child and harassment and criminal mischief.
Well, Ms. Stanley, I think probably the more important question is whether or not changing our code midstream does anything to the ability to prosecute any of those cases. How would the court?
Oh, they're currently open.
Correct.
Yeah, I would. I think just off the top of my head, because I haven't had that question before. I would think any open cases would be prosecuted under the current code. Even if we change the code, next Tuesday, open cases would still be prosecuted under the old one. But I mean, these cases aren't going to stop coming to us, unfortunately. So it would just really help all of our cases in the future. The next several thousand that come in the door would be easier to prosecute.
Okay, that helps. Thank you very much. Thank you, Mr. Chair.
Thank you. Ms. Alderton?
Thank you, Mr. Chair. My question is a follow-on one that Ms. LaFrance asked earlier. With regards to harassment of posting images or online posts as it could apply to minors, if we are not talking about items that would rise to the level of child pornography but are otherwise harassing, would this code apply to the prosecution of minors for that activity?
No, because minors are prosecuted in my office unless they committed DUI. An OUI. All minor cases go to the Department of Juvenile Justice for prosecution.
May I do a quick follow-up, Mr. Chair?
Sure.
Sure. So even those cases that are just a violation of the municipal code and no attendance or corollary state law?
Yes, we don't prosecute. The only crimes we prosecute teenagers on are DUI, or we used to do minor consuming alcohol cases. So driving offenses, basically. We can also prosecute them for, open container, that kind of thing. So for driving offenses, we can prosecute them, but not anything under Title 8.
Okay, thanks for the clarification. I appreciate it.
Yep. No, the question, I should have verified that earlier from the question you put before.
Thank you. Mr. Peterson?
Thank you, Mr. Chairman. And I was also going to, I had a question about the harassment situation. With what young people can do with cell phones nowadays constantly amazes me. And if we're going to change and add videos and images, how does the word get out to teenagers that they may do something they think is a prank and all of a sudden it's a felony? And just wondering if anyone had considered that. Thank you.
Yeah, I would have to look up the state laws of if it is a felony, on the level of crime it is for teenagers of the same age, to take pictures of each other. I would have to do my own state law research, but it wouldn't be a crime under our code because we don't prosecute minors. So I don't know if there's an exception for when those older teenagers of the same age, kind of like consensual sex or not. So I should probably do some more research on that. In case there's some exception for same, age children. But as far as getting, I think those crimes have been whatever, felonies or maybe with a few exceptions for a long time. I mean, and they have been. And I think, I don't know if the state has updated its code to include, or the federal government, and the FBI prosecutes. I don't know if they've updated their code to include video, but I would assume that they have already done so, at least the federal government. So this code change wouldn't change any of that, but I understand your concern of wanting people to be educated on that. And it is scary. I'm actually a certificated teacher, and it is scary to think that your students could get in trouble not meaning any harm. But that is an issue for the state and the Fed to explain. And you know what? The other people who really educate kids on this stuff is the SROs in the school. When kids, cross the line into inappropriate behavior that isn't really criminal, but it's inappropriate with another kid, APs, assistant principals, and counselors might take advantage of having SROs there, have those talks and those sit down and explaining the law, hey. So if you were an adult, this would be this, or if you were older, or if you went a little farther past this line. So I think there's a lot of education that happens with the ACD in our school, which is really great.
Okay, good. I'm glad to hear that. Thank you.
Thank you. All right, I don't see any other discussion. Thanks so much, Ms. Stanley, for the presentation and for answering all of the questions. This ordinance will be back before us for a public hearing and vote on June 8th. With that, I'm going to go ahead and close this work session and wish everyone a great weekend.